The police have charged the accused Mosque gunman with engaging in a terrorist act. They say the charge under the Terrorism Suppression Act has been filed against Brenton Tarrant following a meeting with victims' families and survivors this afternoon in Christchurch. The charge will allege that a terrorist act was carried out in Christchurch on the 15th of March 2019 and follows consultation between police, Crown Law and the Christchurch Crown Solicitor's Office. An additional murder charge and two additional attempted murder charges have also been filed. Law Professor Bill Hodge is on the phone and joins me now. Bill, what does this mean in practical terms?
What it means, and I have to say I'm a bit disappointed. I understand that it's satisfying to use the word terrorism in the prosecution, like the word hate crime. But we don't know what the definition will be upheld by the court, and he will be able to give evidence. I'm not a terrorist, I'm a patriot. Read my manifesto. I'm here to help the New Zealand people, not to cause terrorism. So he's going to be able to give evidence on the meaning of the term, where if they had stuck with the concept of murder, that would not be relevant, and the judge would be able to shut down cross-examination or an attempt to give a speech. Whereas with terrorism, we have never had a prosecution, we've never had an appeal, we've never tested the meaning of it, so both he will be able to give evidence and he will be able to appeal on any conviction. Although it's very satisfying to say, yes, he's a terrorist, he could get life under Section 6A of terrorism suppression, but every law student knows the definition of murder, the actus reus and mens rea, but nobody knows exactly what terrorism means.
So it's untested territory and he could get a platform to espouse his beliefs. So
I like that word, platform. Yeah, he will be able to read his manifesto.
So is there any advantage to laying this charge?
Well, doesn't it feel good? I mean, I guess the police, the prosecution are making a statement, and the statement is welcome because we use this word terrorism. But our old statute, the good, tried and true Crimes Act, was very fit for purpose, whereas the Terrorism Suppression, or it's called the Terrorism Suppression Act, is novel. It's never been tried, and it'll be an experiment, in my view, although it, quote, feels good, but it's just a risk that he's going to get his platform, and that's really what he wanted.
What about penalties?
Well, the penalty for that section, 6A, is life. But the only question under the murder conviction, I don't want to be prejudicial to the trial, let's assume he has a fair trial. If he's convicted on a murder charge, again, the only issue for the judge was, what is the non-parole period? So there was a life sentence already there in the charges, so the police got no additional sentencing ability or sentencing option by charging under Section 6A. So I guess it feels good, and I guess people would say, aha, we're going to charge this guy with terrorism. But how much further along are we in terms of pursuing justice if he is just given an international megaphone to spout that manifesto?
Appreciate your time this evening. That's Law Professor Bill Hodge talking there about the police decision to charge the accused gunman in the mosque attacks under the Terrorism Suppression Act.